No, unless you pay the debt. But there is a caveat here, or an explanation. First, as far as statutory liens go, in essence, unless the creditor accepts alternate treatment, that lien remains until you pay the debt in full. Similarly with the mechanic's lien, if you have not paid the workman who remodeled your kitchen and that person recorded a mechanic's lien, you're going to have to pay that off. Now, you might be able to get rid of your personal liability, but that lien will not be subject to avoidance. Similarly with a floating lien, although if you have a floating lien, chances are you want to keep going with that vendor. You don't want to alienate the vendor. You want to keep the business afloat. And then finally, a tax lien is where there is a little bit of a twist. It turns out that some taxes are dischargeable in bankruptcy. So if you have a tax that's dischargeable in bankruptcy, you can get rid of your personal liability. And if you're really nice when you call up the lien office of the IRS, I'm assuming this is the IRS, and sweet talk them, they may release the lien. So the issue here, I've alluded to a personal liability being discharged, but then the lien still remains. What's going on there? Well, in bankruptcy and in law in general, we make a distinction between a claim against a person and a claim against a thing. Simple example will illustrate the point. It's time to go buy a car. You see the car you want. You take out a loan because you don't have the cash to pay for the car in full. All right. The creditor then gets a lien against the car. What that means is if you don't make the payments, the creditor can retrieve the car and turn around and sell it. So that's a claim the creditor has against the car. And the car is a thing, and in law we refer to a claim against a thing as an in rem claim, because the Latin word for thing in the appropriate objective case is rem. The second thing that happened is you as a human being became personally liable on the debt, meaning if you don't make the payments and the creditor repossesses the car and turns around and sells it, if the creditor sells it for less than you owe, the creditor can come after you to collect the post-resale deficiency. So that's a claim against you as a person. So it's referred to as an in personam claim. The big picture goal in bankruptcy is to extinguish in personam claims. The in rem claims don't go away unless you can avoid them in some way, such as the avoidance of a judicial lien. So those liens still remain. Those in rem claims still remain, even though the in personam claim has been extinguished. In practical terms, what that means is if after the bankruptcy, you don't make the payments, the creditor can't garnish your wages, can't seize money out of bank accounts, but the creditor still retains the lien against the property, so that if you want to refinance or sell the property as part of the transaction, you have to pay it off. And if you don't make the payments, the creditor can repossess the property. Now, if the creditor comes up short after repossession and sale, the creditor cannot come after you to collect the post-resale deficiency. That's the point of getting rid of the in personam liability. But the taxing authorities, if you really do have a dischargeable tax and it's discharged in its entirety, have been willing, at least in my experience, to release the lien.